Okay, here I am again, but this time to travel with you, because the trip to getting there, if we ever got there, is similar to the story of Odysseus. Homer described the story of a warrior who, on his return back from the Trojan War, actually had to face a lot of challenges. So he would take the boat, trying to reach his Ithaca. Let's see how this trip started for Greece. The evolution of mediation laws in Greece, and I'm following up on my dear friend Giuseppe. It all started for us again with the EU directive. And I still remember when he first came to Greece, because Italy was like a thought leader in the field to teach about mediation. And so we started with the EU directive. We went on to adopting the EU directive purely on voluntary mediation in 2010. Later on, we made an effort to reform EU law in 2018 that was unsuccessful. And what we have today is a law as of 2019 that actually puts mandatory mediation in place. Let's go back. So this is the story. We had 7 years of doing what with mediation? We did have a law after the introduction after the EU directive and the harmonization into the Greek legal system of what the EU directive would say, purely on voluntary law. Some things did go well, but some things did not go as expected. What went well? Well, it was time for us to revise the code of conduct of lawyers. So we introduced an obligation to inform clients on mediation. We created training institutes on mediation, and in 7 years, we managed to train almost 2,000 mediators. Actually, I was in the position to do most of these trainings, which was very nice. We did have an accreditation committee sitting at the Ministry of Justice to overlook the practice of mediation in Greece. We did organize numerous events, very similar to this one. And we did have not-for-profit entities creating, and a wonderful website hosted by the Ministry of Justice. What we ended up with? Delays of 1,580 days for a first, as an average for a case to be resolved in court. Still the number in the EU Justice Scoreboard, we were first from the last in providing good numbers about how well we actually provide justice in Greece. So going back to what Giuseppe said, was the balanced relationship successfully achieved in Greece after 7 years having mediation in place? Not at all. So what could be done better? In November 2016, and of course, you have to put it all in the context of a country that was facing huge financial issues and was under a lot of memorandums in order to be financed by the IMF and the institutions of the EU. So accelerating justice was a mandate. So this was the time that we started having very low numbers in mediations for 7 years. The discussions started about having mandatory mediation in place. And we did manage to get to a law. Actually, I was a member of the law drafting committee. But the law that we drafted and we delivered to the Ministry of Justice, and that would be interesting to see how policy making can go totally wrong in some places, was not actually the law that was voted in the Parliament. Because the voting process, the legislative process, ended up with changing a lot of things that the law drafting committee would deliver as a conceptual framework for mediation. And that ended up, of course, having an obligation now for the lawyers to advise their clients in mediation, but also the mandatory required first meeting. That was very challenged. It was challenged because the cases were not right. They were adding and deleting cases from the draft. The costs were extremely high. There was fierce reactions by lawyers and judges, and that ended up with another delay, with lots of suspensions until 2019. So you see, the 10 years, we're now almost there. So what we had in 2019, after almost 10 adventurous years, we did manage to bring mandatory mediation first meeting in place. Actually, starting in January 2020, the gods of Odysseus were not with us. That was the beginning of the pandemic. So by the time we were supposed to start practicing how these mandatory sessions would go, we had to go on Zoom, or we had to adapt to new conditions. More delays coming up. And what we have today is a mandatory first meeting session for all disputes above 30,000 euros. That includes mostly commercial disputes, banking dispute, intellectual property disputes, real estate torts. And we also have a specific provision that says if you do have a mediation clause, you need to go to a mandatory first meeting. What does this practically mean? Well, that means that apart from the obligation of the lawyers to inform the clients, parties are notified to attend a mandatory first meeting. Anybody can initiate this meeting. The parties are obliged to attend in persona. That's something that has created already some case law. The mediator can be appointed by the mutual agreement of the parties, but it can also be appointed by a list of registry that we have public. The first meeting should take place in 20 days, within 20 days, in order to meet the Alassini criteria. And one extra addition from the Greek side, lawyers need to be present. That was not a prerequisite at the European level, but that's a prerequisite for lawyers to accept mediation in Greece. Mandatory practically means that for the party wishing to file a case in the court, like the claimant, he has to initiate these proceedings. If not, that would end to inadmissibility of the hearing. Not the inadmissibility of the case as such, but the hearing is going to be suspended to another day. For the parties that are duly notified and not showing up, well, that's the tricky thing. Non-appearance would end up with a discretion from the part of the judge to impose a fine of 100 to 500 euros. There were a few other reforms with the new law in 2019, such as the new code of conduct for mediators, a minimum mediator's fee, that's 50 euros, again, following up on the Alassini criteria for low cost or no cost for mandatory sessions. We have doubled the hours for training mediators in Greece, and that leads to 80 hours now. We have a central mediation committee, we have this public registry for mediation, and we have a requirement to keep statistics. Well, that's quite challenging, as you might see. What we do also have is a nice website hosted by the Ministry of Justice, where people can find mediators and information about mediation and information about the laws and the training providers as well. Ever since 2019, some other attempts have been made now in other laws. One refers to family mediation law that Indra also mentioned earlier. Actually, the new family code, the section for family law in our civil code now has a provision that gives the judges the power to order mediation. That's a step forward. And actually, it gives them the power to order mediation even if the mandatory first meeting did take place. So the judge kind of gets into the substance of the case and say, okay, you might have done it, but you might have done it only for the typical reasons, not for the good reasons. So I'm sending you back there. Another reform has been on insolvency law. Mediation is now part of a process for restructuring debts. And last but not least, we have another law in the cadastral law where mandatory mediation has become a pre-step for resolving land disputes. And I mentioned statistics. Well, here is the tricky part. We do have an obligation to report quarterly to the Ministry of Justice, but it's a mess. The format we use is not good, so the collection of statistics is very troublesome. We also had a very troublesome year in 2020, so the numbers are not really the numbers that the EU can actually collect and work on, but nevertheless, we do have some impressive data here, because it appears that 2 out of 10 of the cases that started because of mandatory mediation first meetings proceeded with full mediation. And we did experience a huge rise in voluntary mediation. So it's not only the fact that we had mandatory meetings, but we raised the numbers for voluntary mediations as well. 2021, similar. We had around 9,000 cases that had to go to this first mandatory meeting. Almost 700 cases settled, and that gives a rate of around 7.63% of the cases that started because of mandatory mediation first meeting, but actually proceeded and settled the case. And again, we're seeing a rise in voluntary mediation. We have now, for almost 10 years, we had 300 cases. And after the first year of mandatory mediation, we have 1,200 mediations, voluntary mediations, with a high percentage of success rate. 2022, now again, the statistics are a bit tricky, but it seems that we are around the same numbers. We're far away. You see Ithaca. Are we going any closer to Ithaca? I don't know. But we do have, again, around 1,000 voluntary mediation and 700 cases that, because of the mandatory first meeting, actually did settle with mediation. Well, are we getting any closer to the Ithaca island? I'm not sure. We still count long delays in Greece. And actually, we do have too many judges. Sorry about the judges. We have too many lawyers. I'm sorry about the lawyers. But we do experience these delays. So, are we going by boat? Or are we using the turtle pace to get there? Obviously, over the years of having laws in place, we have case law emerging. Unfortunately, not a very interesting one. Mostly about the lawyer's duty to inform lawyers and inadmissibility of hearing. Lots about authority to settle. This is a very civil procedural, we have to do mandatory mediation. And what happens with parties of unknown residence? Interesting enough, we had a case law, a case 2 weeks ago, or very recently, that actually a judge sanctions the party that did initiate the proceedings, but only appeared with his lawyer, not in presence. So that's a very interesting finding. He did sanction the person, he ended up ruling inadmissibility of the hearing of the case, not because the process was not there, but party's appearance was not the right one. They only sent their lawyers. That's an interesting finding. I'm moving to the end of my presentation, and I'm going to talk about the sirens. So if you've heard about Odysseus, on his way to Ithaca, he had to face many challenges. Sirens were supposed to be beautiful women, actually half women, half birds, with incredible voices, that if you listen to the voice, they meant to lure all travelers to go to the island and kill them. So how would Odysseus had to overcome these sirens? Well, we do have sirens in mediation in Greece. We have the stakeholders' involvement, We have the need to adapt to the local needs. We have to look at the relationship with the judges. We need to have better statistics. We need to reconsider costs. We need to overlook and supervise the quality and training of mediations, and we need to overcome our sirens. And what did Odysseus do? Actually, he asked the people on the boat to use beeswax on their ears, and he asked them to tie him on the mast of the ship so that he doesn't really give in to the sirens. I guess that's what we need to do and what we need to learn. And I'm finishing this by giving you the poem of Ithaca. So, as you set out for Ithaca, hope your road is a long one, full of adventure, full of discovery. Laestrygonian Cyclops, angry Poseidon, don't be afraid of them. You'll never find things like that on your way. As long as you keep your thoughts raised high, as long as a rare excitement stirs your spirit and your body, keep Ithaca always in your mind. Arriving there is what you're destined for. So, lots to learn for mediation. Lots to learn if you visit Ithaca. It's a beautiful island, by the way. And thank you very much for your attention.